Welcome everyone to the Common Good Project's conversation today. The title for our talk with Professor Rachael Walsh is Constitutions, Property Rights, and Judicial Assessments of the Common Good. And this comes in the context of our conversation series, which asks generally, what is the common good? So my name is Ryan Mead, and I'm the convener of this conversation series, and my co-convener, Chris Conway, is also with us today. We will dispense with our bios. You can find them on the website or the faculty website so that we can introduce our guest today and get into this very interesting discussion. One administrative matter for those of you who have asked, this is the first event. This is our fifth in the conversation series, but this is our first event for Trinity term. And we have had some requests to see if there's a way that people could sign up once for all of the conversations that are occurring. And so we're working on that, and hopefully in the next couple of days, that will be achieved. So please stay tuned for that. As I mentioned, this is the start of Trinity term. Technically, in a couple of days, a Trinity term begins, and we have quite a number of guest scholars. We're very pleased with the response for those who wanted to speak on the question of what is the common good. As always, thank you to the Faculty of Law at Oxford, as well as Blackfriars Hall and the Aquinas Institute at Blackfriars. This conversation series, for those of you who are joining in the middle of it, is framed around a key criterion of Thomas Aquinas' definition of law. And we are using this rendering of the definition of law by Aquinas as an ordinance of reason for the common good promulgated by the one who is in charge of the community. So our guest scholars answer the question, what is the common good, in this subset of the definition from their own perspectives and in their specialty areas. After Chris introduces our guest scholar today, Professor Walsh, I will open the questions to her, and she will provide some remarks, and then we will have a conversation where Chris and I will ask questions with Professor Walsh, and we will leave 10 to 15 minutes at the end for questions from those who are listening in. Please feel free to put your questions into the chat box, and then we will monitor them. We may not be able to get to all of the questions, but we save the questions so that we can develop material as we go throughout the academic year. So with that, I will turn it over to Chris, if you could introduce Rachael.
Sure. Our guest scholar today is Rachael Walsh, who is Assistant Professor of Law at Trinity College, Dublin. Professor Walsh focuses her work in property law, constitutional law, and legal theory. She has established herself as a highly regarded expert in Irish and English property law, and works in the cross-section of property theory in the Irish, British, and US constitutional frameworks. Professor Walsh has published extensively in property theory and is the author of the book Property, Rights, and Social Justice, Progressive Property in Action, which will be published this year by Cambridge University Press. Professor Walsh obtained an LLB from Trinity College Dublin, an LLM from Harvard Law School, and was awarded a PhD from Trinity College Dublin. She is also a qualified barrister in the Republic of Ireland with a BL through King's Inn. Welcome, Professor Walsh.
Well, thank you, Rachael, for joining us today. And we're very excited to have this conversation, because in the lead up today for the conversations we had with our guests during Hillary term, property came up several times. It wasn't addressed head on with respect to the common good. So today we're going to address property head on, because that's what you've dedicated your academic career to, it seems. So with that, I will open it up as for your opening remarks on your thoughts on what is the common good as it may be seen through property law theory.
Thanks very much, Ryan and Chris, for the invitation to join in this series, which I think is just a really fascinating and timely opportunity to reflect on the common good at law. So I suppose the first almost prior question in respect of the common good and property rights is whether or not property rights do in fact secure individual and collective benefits that warrant their recognition as a valuable facet of a theory of the common good. And second, whether and to what extent legal protection for property rights, particularly when we think about the pros and cons of potentially elevating to constitutional status, presents any risks from the perspective of realizing the common good, for example, through creating potential barriers to legislative changes that might be needed to secure the common good. And I suppose at a very basic level, it's important to remember that in the property rights context, the common good is necessarily implicated from the ground up, as I would see it. So property rights only make sense in the context of a community or a grouping of some sort where competing claims in respect of resources can arise. Without social interaction, without commonality of some sort, I have very little need of property rights or property law as an institution to defend my claim over some resource. In this way, various theorists have actually gone so far as to identify social recognition through repeated patterns of interaction as the source of property rights. And I think we can see such patterns of social recognition as very much reflecting collective intuitions, collective views, whether unconscious or consciously formulated, that private ownership does, or at least under some circumstances might, contribute to the common good of some particular institution. I think also at that preliminary stage, it's important to distinguish between the idea of private ownership as an institution that might secure legal protection and how strongly or weakly in any particular context it might be deemed appropriate to protect individual property rights. Those two concepts are often conflated, but I think the common good assessment that's involved in determining whether we ought to have a private ownership system are helpfully separated from common good assessments as to how strong or weak property rights ought to be in any particular context at any particular moment in time. We see necessarily throughout property law, both public and private, resource pooling and burden sharing as core considerations. And those are considerations that will necessarily be centrally implicated in any common theory of the common good. So when we hand these questions over to judges, whether that's through private law protections for property rights or through constitutional protections for property rights, we're necessarily bringing judges into complex conversations and dispute resolution involving questions of the common good. And hopefully that's something we can come back to. I suppose something I've been struck by in observing previous contributions to this series has been the extent to which, at least in certain quarters, ideas around common good constitutionalism have been received as striking or novel or radical. And certainly in the property theory context, the idea that we are all engaged in an analysis of the common good is not novel or striking or radical. So what has been termed property's social aspect or its social function have really come to be widely accepted by property scholars of very many schools of thought as the aim of the game in property law. So while there might be disagreement on the level of priority that we should give to these kinds of moral questions and moral values in structuring and applying property law rules, there's fairly broad consensus on the idea that the end goal of those rules and the application of those rules is some form of enhancement to the common good or human flourishing. Indeed, in that respect, the common good arguments for private ownership are often treated as a helpful guide to where we should demarcate and delimit those rights. So, for example, we can look at civic republican political theory, where the idea of private ownership was fundamentally protected with a view to grounding individuals with independence to facilitate their contribution to the common good. And that set the boundaries, ideally, for the extent of protection that was to be given to property. And we see more contemporary property theories building upon that insight to identify human flourishing as the end goal of private ownership, and as delimiting the scope of individual property rights flowing from that institution. The idea being that mutual human flourishing within a communal society requires mutual recognition of the need for material conditions that facilitate human flourishing, which necessarily imposes qualifications and constraints on all of our individual claims to freedom of use of particular resources. I think there's various reasons that we can see for maybe this comfort or familiarity with the idea that the common good imbues our decision making around property. And I suppose the most notable one is the inevitably, in practical terms, exclusionary nature of property law as a legal institution. The effect of recognizing one person's claims over the use of a particular resource as legally protected is to exclude all others from that resource. So I suppose avoiding any view that property is necessarily relational is very difficult when we look at the nature of at least many of the resources that are dealt with in the context of property law rules, which are by nature such that property law rules have an allocative function that is exclusionary in nature. And the effect of that has really been that property rights have never been, notwithstanding myths that have been perpetuated to the contrary at various points in time in almost all jurisdictions, they've never been absolute. So Blackstone's idea of property as sole and despotic dominion has never in fact been the reality of private ownership's scope in almost any legal jurisdiction. So we can think back to necessity and nuisance as just some examples of extremely long-standing constraints on private ownership imposed through the common law before we get to thinking about the role of the regulatory state in the interests of the common good. So taking all that, I think it's important to reflect on the extent to which there can and is often observed something of a disconnect between this frank acknowledgement and comfort with the moral nature of property in property theory and property scholarship with how it's received and treated in law and politics. And by law and politics, I mean, the courts and judicial adjudication and legislative decision making. Because we can see in both of those contexts often a degree of discomfort, at least in terms of directly engaging with questions of the common good in the property context. So Eric Freifogel points to a really useful example, I think, which is the extent to which the environmental conservation movement, for example, has often shied away from directly engaging with the idea and the term the common good in justifying and framing environmental conservation measures, preferring instead to employ more perhaps scientifically loaded terms like sustainable development, eco-integrity, eco-health, many of which get to the basic idea of the common good in a healthy environment. And equally, I think we can see in many jurisdictions, judges tending to, if you like, hide the common good ball in their decision making, as we will touch upon, be engaged in decision making that squarely involves common good dilemmas, but to tend to obscure the core determinations of fairness that they are making by giving either limited or unclear reasons for decisions, or by conjuring up rule-like distinctions that apparently take the context-specific determinations about the common good that are often involved out of the equation. So understanding the relationship between the common good and property rights requires us to grapple with this complex iterative interaction between judicial decisions and legislative policy making that maybe shies away from at times that direct engagement with the common good on the one hand, and with background cultural attitudes surrounding the appropriate limits of private ownership that are the product of long-standing patterns of interaction with resources, history, culture, and locally determined histories that are very complex. And we add to that the institutional dynamics that are at play here. Like in many contexts, often what's at stake in these debates is who should have the power to speak for the common good. And what we can see in many of these debates are either plays for power by institutions or in fact disclaimers of power, various actors being reluctant to assume responsibility for determining what the common good requires in the property context in various ways. So all of that then raises the question of what does constitutionalization add to this complex matrix, if anything at all? And the question of constitutionalizing property rights has been extremely controversial over time. So whereas many constitutional rights in terms of individual freedoms are taken as almost a given when it comes to constitution making, particularly in, if you like, the third wave of constitution making, the question of whether property should make it a cut was not a straightforward one. And there were significant concerns and continue to be concerns about perhaps the risk of entrenching status quos in relation to the distribution of wealth in particular jurisdictions, and concerns about tying the hands of democratically accountable representatives to make determinations about the appropriate distribution of resources in particular jurisdictions. And I think it's important when we assess that question, what is the risk of constitutionalization, to bear in mind that the language that's used in a constitutional protection probably doesn't matter all that much to that question of risk, because when we look across the landscape of global constitutional property rights protections, we can see that basic foundational questions of fairness and the common good arise whether or not those are stated at the level of constitutional text. So we see the takings clause in the US Constitution boiling down, at least for some judges, to this idea that it is there to ensure that the government doesn't require discrete groups to bear an undue burden in the collective interest. That kind of core distributive question isn't there on the face of the takings clause of the Fifth Amendment, but it emerges as essential to and at the heart of any constitutional protection for proprietary liberty. And we see that question of the common good emerging more expressly in some constitutional orders, the Irish one being one, the German Basic Law being another, where those questions of the common good are, if you like, not embedded in interpretation, but are actually elevated to the level of the constitutional text. But I think regardless of how the clause is framed, adjudication and the complexity of constitutional property ends up at that same point in relation to difficult distributional decisions around how to balance resource distribution and burden sharing to secure the common good, ultimately falling into the laps of judges. So the concern is, well, does that give too much power to judges? Is that likely to lead to judicial overreaching or to such variable context-specific judicial decision-making that the fundamental stability that property law depends on for its efficiency function will be irredeemably upset? In fact, I think when we look at where these kinds of terms are actually employed in constitutional property rights adjudication, ideas like the common good, social justice, social obligation, the result is often a pattern of judicial deference to decision-making by elected representatives on the basic questions around the appropriate balance between burden distribution and resource pooling that's best conducive to the common good in a particular context. Certainly, judicial overreaching does not seem to be inevitable on this question, or indeed even particularly likely. In fact, judges from an institutional perspective seem to fairly consistently have a degree of discomfort, as I alluded to earlier, with directly challenging democratically arrived at decisions around what the common good requires. What we can see, however, is a significant risk in jurisdictions where property is constitutionalized that there may be an inadvertent chilling effect on legislative mobilization in terms of measures that restrict property rights in order to secure the common good. It's difficult to pinpoint that directly to the fact of constitutionalization in a particular jurisdiction, but it certainly seems to be the case that, for example, in the US and in Ireland, where we have constitutional property rights protections, political conservatism around property rights can find support, whether or not it is mirrored in the detail of legal doctrine, in the idea that property is a constitutionally protected right, for perhaps a more conservative approach to interfering with the rights of owners than the common good might perhaps be deemed to warrant in particular contexts. So that is a significant risk that has to be borne in mind. It's a risk that's potentially heightened when one considers that from a constitutional perspective, the meaning of property is often significantly broader than the meaning of property in private law. So generally speaking, most jurisdictions where there is a constitutional property rights guarantee have accepted that that captures a very wide array of valuable interests that might be held by or accrue to individuals. It's not confined to land, it's not confined to money, it's not confined to personal property. In many instances, it captures valuable regulatory entitlements, intellectual property law, rights of action, etc. And on its face, such a broad conception of property in the constitutional context does perhaps not appear problematic. It does when one puts it alongside the kinds of assessments that might be made by legislators in considering whether or not to enact legislation, given that it means that the risk of a constitutional problem flowing from the interference with property rights arises in such a wide array of contexts where you have such a broad conception of property. So that's, if you like, another factor that adds to the risk assessment that a jurisdiction has to take on when considering whether or not constitutionalization is appropriate or not. Property is more than what the courts say it is, but what the courts say it is and what the Constitution says it is will be influential in working out how that relationship between the common good and property plays out within the jurisdiction more broadly. And I might leave it there and turn the floor back to you there, Ryan.
Sure. No, thank you, Rachel. Those wonderful ideas in your remarks, and I want to play out a couple of them to make sure that I'm understanding the train of thought. But one is to make sure the premise of your remarks is that property is social. It might be private and utilized, and we'll get to a little bit more in depth on the theory and philosophy behind that, but that fundamentally it is social, and that it is, like all things, directed to the common good, or needs to be open to be directed to the common good beyond the private use of the property. And near the end of your remarks, as you talked about constitutionalizing property, it struck me as another way to put this could be it hardens the rights, the so-called rights that a person might have around property, so that it makes it more difficult for the state or legislators to direct the property to the common good. So it obviously, this is a balance because as we'll discuss in a bit, don't want to get too ahead of ourselves, that there needs to be some comfort and reliance that a property holder can use the property, but at the same time, have to recognize the needs of the community. So that constitutionalizing hardens and makes it more difficult to use the property or direct the property to the common good by the state. Is that a bit in a nutshell?
Yeah, absolutely. I mean, to speak to your first point in terms of the social, and I think we'll come to Aquinas in due course, but I mean, I would subscribe to his basic idea that, you know, as to its use, property ought to be shared between the individual and the common, in the sense that there are obviously benefits to the common good in terms of allowing individuals to have control of use to a certain extent over property, in terms of allowing them to plan and to develop their lives independently. But at a certain point, a common good assessment may require that control and may deem that control ultimately to run out in favor of wider interests. And in terms of hardening, yes, I think that's absolutely the concern around constitutionalization. I suppose the question is disentangling the strict legal effect of constitutionalization from its broader political and cultural impact. In most jurisdictions, we see that in terms of strict legal effect, the way in which courts interpret constitutional property rights guarantees is actually very soft, and it gives very significant leeway to legislators to make exactly those determinations that you were suggesting about alignment with the common good. Where we see more of a risk tends to be around the wider political, cultural, and perhaps symbolic effect of constitutionalization in putting up those kinds of barriers to legislative freedom. So I suppose my broad sense of it is that political culture and political will, once there, can achieve almost anything that the common good might want to achieve in respect of limiting property rights. Constitutional guarantees don't generally stop that from a strictly legal perspective, but they can do so in a more diffuse way.
I think now might be a good time to pause it and address some of the background concepts that are running around within your comments and are certainly highlighted in many of your publications, which is specifically Thomas Aquinas's view on property and the purpose of property. Do you mind giving us a quick overview of his thoughts on property?
Absolutely, yeah. And his thoughts are really astonishingly modern, I think, when looked at today. So he starts by distinguishing between the right of individuals to use material resources for sustenance and the right to own and to hang on to external goods as distinct from that. So possession and use are distinguished, and he identifies ownership of possessions as not inconsistent with natural right, but rather as a potentially helpful addition to natural right derived from human reason. But the foundational principle is that resources are there for the material sustenance of all equally valuable human beings, and that qualifies anything that comes after in his theory of property. And what comes after really is a very straightforward, easy to recognize story of private ownership as having efficiency benefits, having valuable coordination benefits, and having the valuable function of minimizing disputes around resources within a particular community. So his justification for private ownership is very much instrumental rather than in any way grounded in some concept of a metaphysical connection between the individual and any particular external things. And that's probably why it makes it easy for him to say that the individual's claim falls away when that basic human need for material sustenance comes to the fore and needs to be vindicated. So he argues that, yes, there can be individual possession of external things, but when it comes to their use, all property has to be available for all men, all women, all individuals to meet their well-being needs in terms of material sustenance. And I suppose in institutional terms, he describes that in terms of a qualification around superabundance of material goods. So where an individual has a superabundance of material goods in particular, those have to be made available as a matter of justice to meet the needs of those lacking those resources. So a really fascinating, when we think about the points I made earlier around the general recognition now of property's social aspect and social function, he has a really fascinating way of framing that in a way that allows you to at once recognize private ownership as an institution, as valuable, as having very significant benefits from a common good perspective, but at the same time to identify that any of those benefits do not weigh in favor of absolutist protection for property rights.
And I think, Rachel, that is one of at the heart of Aquinas's thoughts on property. And for those who are listening and haven't looked at some of your publications yet, or read some other things on Aquinas on property, it really does strike me as modern in many respects, and very advanced in the thought, because he poses in question 66 a way that property is both common and private, which is central. When we look at the history of property law, we do see this, and I think this is the point that you were making earlier, is that property law, property as social, property law is the question of the common good has not been controversial in the history of looking at property law, where it seems to be the question of common good is surprising to many people outside, or they're not quite sure how to handle it. But Aquinas has this notion that that all things are possessed in common first, according to the natural law, and then it's positive law, which provides property rights or property use, or defines the limits and the privileges of property use. So you get to private law, you get to private property via positive law, and natural law, justice, the common good may require the positive law to secure private property and make sure that there is reliance in you and to be able to use and so forth. But at base, property is common, and that it is simply positive law, using prudence and trying to direct it for human flourishing, where we get private property. So we get this, to me, fascinating balance of common and private at the same time. One question, I suppose, coming out of this is, it also strikes me that there's no such thing as private property pre-state. If we can imagine a pre-state, and I don't mean in a Lockean sense of before a social contract, but just, if it's the state in positive law that gives us the private property contours out of common possession, there would be no pre-state property, private property. Is that something you agree with, or?
Yeah, I mean, it's something I find fascinating in Aquinas's work on property, and probably the part of his theory that I grappled with the most is precisely, he's difficult to pin down, I find, on precisely how necessary he regards private ownership at an institutional level. So he's very clear that when it comes to use and individual rights in respect of determining the use definitively over external things, those are very much qualified, and those are very much subject to human reason and the requirements of the common good. He's a little bit more ambiguous, as I read him, in terms of how necessary private ownership as an institution is. And certainly my take is that, he identifies private ownership as, yes, part of human law, positive law, but one that flows very closely from that natural law principle that the goods of the world are there for the material sustenance of all. So to my mind, he treats it as an elevated positive law principle that he identifies as very much necessary to peaceful, efficient, and dispute-free human interaction. So in that sense, he might regard it as something that exists in a natural state, but certainly he I think leaves himself open to the possibility that not always, not in all circumstances, that it is a contingent judgment of human reason in each context as to whether this is the best way of securing that basic principle that external goods be available for the material sustenance of all beings, I think.
It also strikes me this works wonderfully with the principles of subsidiarity, because it would allow local jurisdictions to be able to assess the needs of the community rather than having a universal law or rule about what is private property or the extent and when private property might be taken or used by the state, it fits in nicely with subsidiarity.
Yeah, I read Aquinas is extremely non-prescriptive around what a particular property law regime will look like, or the strength of individual rights that would be protected in any private property regime. Where he is a little stronger is in suggesting that as a concept, private ownership has benefits for the common good as he sees it.
And I'll just add this before I turn it over to Chris to ask some questions about your new book, is that for those who are listening and haven't read Aquinas on property, he gets to the notion of property by trying to tackle the question of theft and robbery, and then he has to back up to so it's a very interesting approach that he takes, because he's starting with a moral question. I mean, one could say property is a moral question, of course, as well, but he's starting with a very defined moral question on theft and robbery, and he backs up to say, well, what is property and ownership?
And really interestingly, I think in his treatment of theft, he gives us more or less exactly what we now have as the common law doctrine of necessity in most jurisdictions, a very narrow circumstance in which he identifies it as justifiable, not a sin, to take property from another to secure urgent needs that can't otherwise be satisfied, reads to a contemporary common lawyer more or less exactly like our narrow fit common law necessity doctrine.
Professor Walsh, I'd like to ask a question about your book, which I had the pleasure of reading a draft of, and this is a book that will be published later this year. I first want to say that it's a very fantastic examination of property law, and is also extremely well written and clear. So I commend you for that. This is a book which is making a very compelling case for the common good in property. But before asking some specifics about your ideas that you raised in the book, I'd like to ask you about the use of the term progressive, which is in the title and you mentioned throughout. So what do you mean by progressive in this sentence?
Thanks, Chris. So, I mean, it's not my term. I wish it was. I'm coming too late to the debate to claim it as my own. I suppose progressive property is a school of thought in property theory that has always been there, as we've talked about the idea of property's social aspect and social function not in any way being new, but that term progressive property probably crystallized around 2009 when you have a statement of progressive property from a group of scholars at that moment in time who were really trying to provide a riposte to, at that stage, the dominance in particular in US property theory of law and economics readings of property law and justifications of property law, and say, well, look, property law is about much more than efficiency, maximizing preference satisfaction. It is fundamentally about social relations. It's grounded in a plural range of values that have to be mediated through rational judgment. It entails not just rights, it also entails obligations for owners, and that when looking at property and considering the justifications for property, one needs to think about its exclusionary effects as well as its empowering effects. So it was, I suppose, a reigniting of a debate that had already been there around property's relational aspect and how that ought to be reflected in both private law and public law contexts, and a response to arguments that property rights were an impediment to collective action, to improve democratic systems, to enhance human flourishing, to protect those on the margins, etc. So it's a school of thought that has, close adherence and has then spread out to influence applied theories of how particular areas of property law ought to be reformed, mortgages law, landlord-tenant law, etc. And has that, spread beyond the confines of US property theory to find its own manifestations in English property law theory, and my own work's been influenced by it. South African legal theory around property has been heavily influenced by it. So that's ultimately what I mean by progressive in that sense.
And I think picking up on that and the notion that property is relational, or as I described it earlier, social, would it be, at the risk of wandering into some technical language, would it be fair to describe a property holder as a type of trustee of property who can receive benefits from the property, has wide privilege over the property, but ultimately is not vested in the property?
I think that's a really interesting choice of language, and it brings to mind formulations of that basic idea of the social aspect of property that have been in vogue, if you like, at different moments in time. So the idea of public trust and stewardship, for example, both of those concepts have been particularly influential in arguing that in the environmental context and with a view to environmental protection, property rights shouldn't be protected in an absolutist fashion. But yeah, I would fundamentally agree with you that what we are talking about here is a significant qualification in any idea, harking back to the Blackstone comment earlier, that exclusive control over use and possession naturally flows to the owner of any particular resource. And it speaks to a long-running debate within theory around property social aspect as to how we should best conceive of that social aspect. Should we think about it as an inherent constraint on an owner's freedom? So that's been framed in terms of ideas like a social obligation or an obligation of attentiveness that is a feature of ownership per se, or is the focus primarily on justifying constraints, whether those are imposed through private law adjudication or through public law measures, on some preconceived notion of what an owner's rights can entail? And that's a debate that has been fairly intense, and many on the progressive side of the debate have stressed the need to treat obligation as inherent to ownership. And there are various reasons that one might take that strategy. For the first point that we consider is the extent to which it minimizes the need to argue for redistribution. So if property is inherently limited, the state then in acting to secure the common good, or courts in intervening, are not actually redistributing property. They're simply giving effect to a feature of ownership in policymaking or in judicial decision making. So that's attractive for various reasons, potentially. I think it also speaks to potentially distrust of the potential for political systems in and of themselves to adequately vindicate the common good through restricting property rights where necessary, because it holds back some control over defining and implementing that social aspect for courts through adjudication, rather than, if you like, delegating wholesale responsibility for that to political actors.
Mm-hmm. And I specifically used in my question a technical legal term, trustee, which of course in order to convey the idea, it would be very difficult, I think, as the theory develops and is implemented, to displace the term trustee. But I think you used a term which is more precise of trying to get to what I was trying to convey, and that was steward or stewardship, which of course the literature talks quite a bit about stewardship. And I can't help but think, I'm not one to take political philosophy from Lord of the Rings or from Tolkien, but I can't help but think of the steward of Gondor, where the king is gone for a long time, and the steward is a type of trustee and waiting for the king to return. So benefits, privileges of use. So I don't know if he was referring to property law or property theory or quinas. He might have been, but I think this concept of steward is a really a great notion here.
I think it's probably where we've gotten to. I mean, trustee probably takes us to the holder having to put the interests of others above the holder's own interests in respect of the resource. And I think the theory probably hasn't gotten to that level of socialization in property's function so far. Stewardship probably gets closer to that notion that yes, the holder's interests and plans and desires for the resource are of primary significance, but not determinative significance in relation to the use of that particular resource.
Since we have a law professor teaching in the Republic of Ireland, we'd be remiss if we didn't ask a few more questions about the Republic of Ireland's written constitution. This course has explored what is the common good, but the Irish Constitution not only offers the term common good as an important criterion in law, but also uses the term social justice. As we understand from your publications, the Irish courts have been more open to giving definition to social justice than the term the common good. So first, what does Irish jurisprudence consider social justice to be? And why do you think the courts have shied away from the term the common good in favor of this term social justice?
A really interesting question, Chris. I mean, really, they've been quite wary of dealing with either concept in any detail, I suppose. So, I mean, one of the things that prompted me to write the book that I wrote was that within progressive property theory and thinking about property social function generally, there's, if you like, a lot of hope placed in these kinds of concepts: social obligation, social justice, human flourishing, as vehicles for reforming property law, and as judges as primary drivers of that reform. And I suppose I had come through a jurisdiction where we have those ideas at the level of the constitutional text. They're expressly stated to qualify individual property rights, and we haven't seen a huge amount of independent engagement by judges with those concepts, the formulation of their own ideas of the common good and social justice. So there is a degree of discomfort. I mean, in the early days of our constitution, which was adopted in 1937, we have judgments where the courts are saying, look, we just can't deal with these concepts at all. These are solely matters for political determination, and it is not our position to comment in any instance on what the common good or social justice requires. Now, we've moved on from there, but the basic idea that the primary arbiters of these ideas are politically accountable branches of government in our system of governments has persisted. That said, we have had some germs is probably the best I can put it of an interesting way in which the idea of social justice could develop in this context. So we had an interesting judgment from our Supreme Court in 2005, which suggested that social justice requires us to think carefully about the particular impact of property rights restrictions on vulnerable communities. So to take a more personalized and individualized look at how measures that are brought in the interests of the common good may impact disproportionately on particular types of individuals or owners. So an emergence of ideas around identity and vulnerability as driving social justice in distinction to the common good. I think what we can see with the common good is that it is, if you like, become subsumed in more modern vehicles in constitutional adjudication for similar ideas. So the idea of proportionality is a very important concept in our constitutional legal order. And I suppose a lot of the analysis that judges might have done under the rubric of the idea of the exigencies of the common good has become subsumed in a more blandly structured framework for judicial analysis in the proportionality principle. And we have some suggestion in a High Court decision that the courts may perceive a distinction between social justice as concerned with the objective of a measure introduced to secure the common good, and the idea of the common good as more concerned with the means through which that objective is to be realized. And that question of means has now tended to be looked at through the prism of proportionality analysis, and there has been a jettisoning of that language around common good. I think also, reflecting on where we've moved in terms of the Irish Constitution, there was a degree of discomfort with language in the Constitution that was seen to be very directly influenced by Catholic social teaching, and a tendency to read that out, whether through scholarship or through judicial reasoning, in favor of language that seemed more readily to fit the model of a liberal constitutional order, I think.
And speaking of moving forward into a liberal constitution of order, there is in contemporary property law, and I suppose in talking at all about property law and calling it modern or contemporary, that doesn't mean in the past 20 years. That might mean the past couple hundred years or 150 years. There is the term bundle of rights, and the bundle of rights has become a key concept in property law. But it has had its proponents and detractors. Probably one of the stronger arguments that, against the bundle of rights has come from people who have studied and looked at Roman law, and to see what insights does Roman law have for property law today. And in Roman law, property, this is not doing it justice, but property is put together of sorts with obligations in the various categories. So it is tied more closely to obligations than to some of the other categories. And some have suggested that is a better approach to property theory than this the bundle of rights, a group of sticks tied together of sorts. So what are your thoughts about those two concepts?
Really interesting. I mean, I think the bundle of rights debate has become probably it, plus the question of whether the right to exclude, if you like, defines or is the essential feature of an owner's rights. Those two debates have become real hot buttons for dispute now between theorists who are perhaps more or relatively less concerned with structuring property law to prioritize its social function or not. I think your question is really interesting in that it gets at the question of whether the bundle model itself has any predisposition in terms of lending itself to a more or less common good obligation conducive regime. And I think it probably, my sense is that it doesn't. While I don't in any way disagree with there being benefits to aligning with the idea of obligation and bringing that more front and center in property law and emphasizing its relational aspect, the bundle of rights model has that relational aspect bedded within it, albeit that it's one that's perhaps not as intuitively to the surface as a layperson, in particular, when one thinks about property in terms of a bundle of rights. It doesn't necessarily say much to the ordinary individual about what property entails for them in relational terms on a day-to-day basis, in the way that maybe the obligational model might give a better sense that what we're, first and foremost talking about here is how we regulate interpersonal relations and obligations flowing from those around how various valuable resources are regulated.
We're coming to the bottom of the hour, but we do have time for a couple more questions here. The first is in the chat box from Jill Robbie at the University of Glasgow. And she is wondering about your perspective about resource use licenses like mining and water licenses as constitutional property entitlements.
So a really interesting question, and I suppose the first point I'd make is again that concern about whether or not constitutionalization and opening certain issues up to the debate that comes with recognizing a right as constitutionally protected is good or bad. My sense is there probably isn't too much risk to those strategies from a legal perspective. So from a legal perspective, recognizing mining licenses as constitutionally protected property rights would not, I think, in most jurisdictions result in negative outcomes from a common good perspective, if in that respect we're thinking about environmental protection. But again, the concern that I would have is, do these put up softer barriers to political action and encourage political conservatism in these kinds of contexts? Once that is called property, it has ramifications culturally and politically, even if the strict legal effect of that denomination may not be a significant hardening in protection, to come back to the term that was used by Ryan earlier.
I think we're about at the bottom of the hour here, so I'll just ask one last question. This is a practical question. And one of the fascinating aspects of your writings is that we see you working with theory and practice. It can be difficult to do theory and apply theory at the same time, but property law theory seems to be very well suited to have both in play. Do you have any advice for academics and practitioners, and especially our students who are working outside of property law, on how to keep a balance between theory and practice in their work?
I suppose it depends on the problem that you're dealing with. I find that particularly in the property context, we are living in an environment where property rights and property disputes are around us every day. As I always tell my students, this may seem like a technical and archaic course, but actually so much of what you will learn in property law will be of real relevance to your lives. So as a property law scholar, I just find it hard not to think about application, but at the same time, so much of our intuitions around property law come from property theory that is very much culturally embedded, ideas like Lockean labor theory, etc., that just are part of how people think, consciously or unconsciously, that again, to look at property law without thinking about theory gives you an extremely impoverished view. So I suppose my suggestion would be, at least in most contexts, to think about how those two sides of the coin are mutually illuminating. And I suppose that from most theoretical perspectives, there's probably something to be learned from looking at application in terms of identifying either challenges for the theory, or certainly my experience was opportunities for theories to be more effective if their goal is to change or improve the law in some way with a view to enhancing the common good. Looking at application can help you identify gaps, levers, spaces where there's perhaps room for action in terms of theoretical development.
Well, we've come to the bottom of the hour, and thank you so much, Professor Walsh. I think this has been a great conversation. I have a feeling we could go on quite a bit longer with this, and perhaps maybe sometime we will, because there's many more things that are fascinating to explore in property law. Your last point struck me when I took property law as a student. I recall about 1/3 of the course seeming quite archaic to me, and liking history and philosophy, I enjoyed that part, but I didn't quite understand or appreciate at the time how in property law, particularly, the history is alive today in the workings of the law. So thank you very much. We had a few more questions which came in, which we'll answer in a follow-up. But again, thank you for your time. When does your book come out? I know it's coming out soon. Right?
August, hopefully.
August. Okay. All right.
Well.
And again, I echo Chris's comments. We had a chance to take a look at the draft, and it's a really wonderful book. So I encourage everybody to pre-order it if you can.
Thanks, Ryan.
So thank you very much. Please feel free to sign up for next week. We have two guests, and we will continue the question of what is the common good. Thank you.